Mr. Chairman, can I get my panelists up here? There is one panelist that could not attend. Her name is, I think Sandy knows, Sara, who testified on the House side but could not attend the hearing today, but she submitted for the record a recording of herself on her testimony. Okay. Everybody here? Yeah. Hey, guys. Okay. SB 769 is a reasonable and thoughtful way to apply justice in circumstances where the law provides punishments that do not fit the crimes. When child victims of sex crimes commit serious offenses against their abusers, there is a limit of 1 year from the time of the abuse, so this is not a green light to hurt your abuser. Rather, it provides no protection from adult prosecution. What it does allow for is the mitigating factors of the abuse the youth suffered to be considered for sentencing and to have appropriate standards apply in the sentencing process. As you know, adverse childhood experiences, which are referred to as ACEs, are more than a catchphrase when it comes to juvenile justice system, especially concerning victims of sex crimes. And studies have shown approximately 90% of children in the juvenile justice system have experienced at least 2 ACE, that is adverse childhood experiences, and about 48% have experienced 4 or more. The population we are discussing under this bill, specifically youth victims of sex crimes, is self-evidently above the high end of these broader studies. Consider nationally that 73% of all juvenile justice involved girls have histories of physical and sexual abuse. In combination with traumatic bonding and post-traumatic stress disorder, children with undeveloped brains cannot control their emotions and impulses and cannot evaluate the risks the same as adults do. These mitigating factors must be considered at sentencing for these specific children for these specific crimes against their abuser. And this bill is not a safe harbor bill, such as the one you'll hear next week for nonviolent crimes, but this bill does cover similar population of child victims and sex crimes. Our state does not have a real duress defense for coercive circumstances. So short of a complete defense, this bill is just asking for a more reasonable application of sentencing for youth victims of sex crimes, only for crimes against those who abused them within 1 year of that abuse, which has to be proven by clear and convincing evidence. And of course, you'll hear from the victims of abuse who later were victims of the criminal justice system. They can tell you their stories best, but the common denominator is the law is not flexible enough to allow judges and prosecutors to dispense justice, and not just the brutal force of inflexible laws. The intent of this legislation and the actual language contained in this bill allowed sentencing judge to consider the mitigating factors of child victims of sex crimes when they commit a crime against their abuser. We can resolve real and perceived technicalities for these kids and for justice generally. The opposition neither points to technical concerns that our amendment confronts. We have an amendment. You might look at the amendment when you get it. Brings up examples outside the scope of the bill or calls this process duplicative. This legislation is needed and has technical soundness as well as narrowness to apply only to individuals that must be so hard to find that no relevant examples can be summoned to oppose this bill. For these reasons, we request a favorable vote on SB 769 with the technical and clarification amendments to confront the concerns of the judiciary that are relevant to this bill. I'll turn it over to my panelists. Would you like to speak first?
Sure.
Thank you, Mr. Chairman.
Thank you so much, Mr. Chairman. James Dold, for the record, representing Human Rights for Kids. We just want to start at the outset thanking Senator Lee for her leadership in introducing this bill. I come before you both as the CEO and founder of Human Rights for Kids, as well as a survivor of child sexual abuse and child labor trafficking that I experienced as a child. One of the reasons that really animated my life's work to work on behalf of the most vulnerable children in our communities. There's two really important critical points of this bill that I want to spend time speaking about. The first is the first section. And what this section does is it just requires that when judges are sentencing children who've been transferred and prosecuted and convicted in adult court to consider specific mitigating factors of youth, including their age, their trauma history, what their home and community environment were like, their intellectual capacity. These are all critical components to make sure that whenever a judge is imposing whatever sentence they're going to impose on a child, that they have a full scope and understanding of who that child is before them. This is particularly relevant for kids who have very high adverse childhood experience scores. I will also just note that this same exact language was actually adopted more than 8 years ago by the conservative state of West Virginia. The second part of this bill deals with the protections that Senator Lee specified, which are for child sex crime victims. The case that really animated this legislation was that of Sara Cruzan. Sara was an 11-year-old girl who was walking home from school who was preyed upon by a sex trafficker. From the age of 11 to 13, she was raped by this man. Then from 13 to 16, he forced her into prostitution. She ran away for a week, she returned, and she killed him. And the entire weight of the criminal legal system came down on her. She received a life without parole sentence, plus she had to pay $10,000 in restitution. We see cases like this all over the country, cases of Centoya Brown, Alexis Martin, Jared Harper, Patrice Smith in New York. It should not take an act of the governor to intervene in cases like this, and what I would submit is that if this was your child, if this was your son or daughter who had been sexually abused, raped, or trafficked, and they killed the person who did that to them, what should we do in those cases? Our answer to that question says a lot more about us than it does about that child, and what this bill does is simply give the judge the ability to send that case back down to juvenile court for proper disposition. Child sex trafficking victims and child sex crime victims are the victims in these cases. And we need to give judges more flexibility in these very unique circumstances. And for that, we would urge this committee's favorable report. Thank you.
Thank you. Has everyone had the opportunity, please?
Good afternoon, Mr. Vice Chair and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent both youth and youth charged in, as adults in the criminal court system. What brain science has told us is that children are different. And that is especially true for children who have experienced trauma. And in fact, most children within the juvenile justice system have experienced what Senator Lee was referring to, adverse childhood experiences. As a result of that trauma, children react differently to situations that may not be perceived as a threat to your average child, let alone your average adult. But the problem is that our criminal justice system here in Maryland treats those children as if they were adults. Our criminal justice system ignores the trauma and the experiences that these children have been through and doesn't give them the option of being treated like children. Transfer to juvenile court is currently unavailable for a 16 or 17-year-old charged with murder. And so if you have a 16 or 17-year-old who has been a victim of trafficking, who has been beaten, who has been broken by an abusive adult, and finally reacts and strikes back against the person who has stricken them repeatedly, that 16 or 17-year-old child is incarcerated with adults, punished as if they were an adult, without consideration for what they've been through, without the option of getting the treatment and rehabilitation that they need. And if these children could only get the help that they're asking for, they could be rehabilitated. The underlying trauma could be addressed, and they'd have a chance for a life ahead. Instead of the continued sexual abuse, the rape, and the suicide-inducing conditions of the adult prison system, especially to vulnerable youth. I've provided quite a few statistics in my written testimony, but what I would ask this committee to do is when we see a 16 or 17-year-old who is crying out for help, we shouldn't discard them, and instead we should offer them assistance. And for these reasons, I urge the committee to issue a favorable report on SB 769.
Good afternoon, Vice Chair, Chair, members of the committee. Elizabeth Hilliard with the Office of the Public Defender. I am standing in for Kimber Watts. You have her written testimony in which she extensively discussed three things I will touch on today. First, as McCall and James both pointed out, children are different. You've heard about this extensively today. I know you've had juvenile justice bills in front of you all day. What we know and what the Supreme Court has consistently recognized for the past 20 years is that a child's brain is not fully developed. That means two things. First, often a teenager is more prone to making risky, unmeasured, and dangerous decisions. And at the same time, the part of their brain, the part of your and I's brain that would put a brake to that would calm us down and ask us to think about long-term effects, about the impact of our decision, is not yet developed. So when someone is, let's say, 12, 13, 14 years old, they are not the same person they will be at 25, 30, 35 years old. This bill simply encourages, requires, and ensures that a judge will consider such circumstances before imposing a sentence on a child. Second, children are extremely susceptible to peer pressure in a way that is perhaps unconceivable for those of us who have been removed from the, let's say, foibles of youth for the last 20 years. The Supreme Court has recognized, in fact, that even without peer pressure being exacted out loud, mere awareness that peers have been watching encourage children to engage in risky behavior. To illustrate how this plays out, we have a specific client story, and I think it's encapsulated in Kimber's testimony, so I won't regurgitate it here because I'm running out of time. But we urge this committee to report favorably on Senate Bill 769, and thank you for your consideration.
Thank you very much. I don't know if I should be asking this of the sponsor, but I was looking at the judiciary's written testimony and just had a couple of questions. On page 2, line 18, they mentioned something about the constitutionality of faith being included in this, and so I'm wondering why. That's the first question. The second question, and I'm not clear why, on lines 23 and 24 is saying that the court may not require that a comprehensive mental health evaluation be conducted. I'm just curious why you would want to take that tool away as well.
And if I may respond, Senator, so that's actually what the amendments that Senator Lee has offered do address. Those amendments address all of the concerns that were raised by the Maryland Judicial Conference. So that faith and will be taken out. That subsection 2 will be struck and replaced with finding on the record. So we tried to make sure that we took into consideration all of the concerns that were raised in their testimony. So they shouldn't. From my understanding, they shouldn't have any more issues, at least what was addressed in their letter of opposition.
Thank you.
You're welcome.
Thank you, Mr. Chair. So I'm looking at the second half of this. The first half has this statement that the court may not require a mental health evaluation, but some of these standards that the court is required to consider, it seems to me, would necessitate a mental health exam. The minor's ability to appreciate risks and understand the consequences of actions, the judge couldn't possibly determine that just by having the person sit in court. Excuse me? Oh, I'm sorry, you're taking that out?
Yeah, so the court can still order those mental health evaluations, and it can be considered under that factor. It's just that we struck that other subsection that said that the court can't order that.
Okay.
So, yeah.
All right, so that makes the bill consistent. So now I'm looking at the second part of that. So I'm looking at the literal language, which is the way I like to read bills. If the court determines by clear and convincing evidence that the individual against whom the minor is convicted of committing the offense previously committed a sex crime or human trafficking against the minor, and then certain things happen, So we sort of, in cases in which a husband enters the house and sees the wife in bed with another man and lashes out in a fit of passion, there's certain considerations given by the courts. But in this case, there's no requirement that it be a crime of passion. It's just if there was a sex crime or sex trafficking within a year, then if the defendant in the case kills the person who did it, first-degree murder, no passion involved, just comes and finds the guy within a year and kills him, then the defendant gets special consideration. I don't think we have anything like that in the law, do we?
Well, so I would say, Senator West, to respond. So this actual language, I will say that there's actually similar legislation pending at the federal level that the National District Attorneys Association supports. That also factors into this. So that's one thing that I'll say as far as the standard goes. But it is about child sex crime victims who, again, the victim in the case, right, that they're being charged with, are the people who committed that act of sexual violence.
No, I fully understand that. So somebody was foully abused. But what this almost does is give that person license within a year of the abuse to seek out the abuser and kill him.
So Senator James Dole, again, if I may respond, it's not about giving license or legalizing vigilantism. It's about recognizing that these children are victims of crime and that the court, in the court's estimation, they may say, look, I've considered all of these different factors, and I don't think the proper venue for this child is an adult court.
Well, okay, let's go to that then. That's the second half. So the presumption is that someone who sought out her abuser and killed him, the presumption is that that person, the minor, should be transferred to juvenile court. But in juvenile court, if you're convicted of a crime, when you no longer are a minor, when you turn, I think it's 21, you get out. And you're no longer incarcerated. So what this bill really seems to do is to authorize, I know what wasn't your intent, but the effect of the language seems to be to authorize someone who's been abused to kill the abuser and then go to juvenile court, and when she reaches the age of 21, she's free as a bird.
So I'm gonna let some of the public defenders come up and respond to that as well. But I will just say, from our perspective, these children are the victims in this case, right? And that we want to give the court as much flexibility as possible. And it may be the case that the judge, wants to impose an adult sentence. That may be appropriate. But if we're talking about a kid who's been sexually abused and raped over a period of years, and then they run away like Sara did, for a week, and they return and kill their abuser, our position, we don't believe that those children should be getting adult sentences. We believe that the judge should have as much flexibility as possible, and that the system really should account for the fact that these are the true victims in the case. Not to excuse homicide or any other crime, but these are very unique circumstances.
This comes close to excusing homicide.
Well, it just opens up the opportunity for the court to have more options. That's the way that we look at it. And I'm going to let OPD respond as well.
Thank you, James, and thank you for your question, Senator. I appreciate it. I certainly also appreciate a very literal reading of the text, and I'll direct you to the provision that says page 3, line 4, at the end of the line, the court may transfer the minor to the juvenile court.
Yeah, but
for
look at the
sentencing.
next section. It says there's a presumption that the court should transfer the minor.
Yes, but it's still permissive. And in the circumstance which you're raising, which I think is very unique and few and far between, there would be absolutely no issue with the court rebutting that presumption. If you are creating a circumstance or a hypothetical in which someone, a 16-year-old who was the victim of sex trafficking or another sex offense under this title, was aware of the law and plotted an exacting revenge, which I would actually argue under their brain development would be likely impossible, the judge could make those decisions and rebut the presumption without having to follow the remainder of the sentencing provision. So the discretion in this bill is still retained by the judge. It merely reflects the import of victimization, and Michal is going to talk a little bit about battered child syndrome and battered spouse syndrome that would apply in circumstances such as these. This bill, although strongly favoring juvenile sentences for folks who have been victims of abuse like this, still allows the court to maintain full discretion.
Okay, thank you.
And Senator West, if I can just respond. So the scenario that you gave, a spouse walks in on their spouse cheating, in the act of cheating on them, and kills their spouse.
In a fit of passion.
Right. And that's exactly what that is. That's considered a crime of passion. And the way that the courts deal with that is that that's a mitigating factor, that it was a crime of passion. That's not what we're talking about here. What we're talking about is actually more in line with battered spouse syndrome, or in this situation, what it really is battered child syndrome. It's an individual who has been repeatedly traumatized by their abuser over a period of sometimes years, whether it's months, whether it's years. When we're talking about a child who has been repeatedly battered by this specific abuser.
Well, the bill doesn't use the word repeatedly.
Right. So,
It's just a sex crime.
yeah, but it's specifically somebody who has been trafficked.
Right.
And that's what that paragraph speaks to. So we're talking about somebody who's been repeatedly abused, repeatedly trafficked by this person. And it's not that they're plotting for a year to go and kill this person. It's that they're stuck in a situation where they perceive that situation as a threat, whether or not there is the normal legal definition of an imminent threat that you would need for self-defense. Because what happens is, because of the repeated abuse by this abuser, much like in a battered spouse syndrome, when you have a battered child, they perceive a threat where it might not be there. So because they've been repeatedly trafficked by this person coming over and calling them honey might be enough to trigger that. It's the perceived threats by the specific person who trafficked them that lead them to those actions. So it's not as much a crime of passion as it is a result of their trauma response to the situation, their trauma response to a triggering event by their abuser.
Okay. I hear your answer, and I'd appreciate it. There's nothing in this bill which seeks to differentiate a traumatic response, on the one hand, from someone who coldly plots to kill the person who has abused her within the year set up by the bill.
And I understand that concern, and that's what my colleague, Ms. Hilliard, was referring to, that these are things for the judge to consider. So it's because each person's pattern of abuse is not going to mirror the others, it's impossible to prescribe, here's how you fit into this pattern of abuse. But what this bill is asking judges to do is to consider that pattern of abuse, consider what this child has gone through, and make those considerations in deciding, what does this child need? Does this child need services? Does this child, should this child's case remain in adult court?
Okay. Thank you very much for your answers.
Just real brief, somebody had said that the juvenile's sentence for an adult crime would be serving their sentence in an adult prison. That's not correct, is it?
So it's a 16 or 17-year-old child charged with murder would be serving that sentence in an adult prison. So it's a child charged as an adult.
So they would not serve it in the juvenile adult prison, or the juvenile prison. They would serve it with the adults. They'd be sending in
Once they turn 18, they are transferred to the Department of Corrections.
No. You
Oh.
said the child. Now they're not a child, because now they're 18. But when they're 16 and 17, they're not serving it with the adult population, correct?
They're actually kept separate from the adults in the Department of Corrections in a facility in Baltimore.
Right.
And then the day that they turn 18, they're sent to the
And they
Department of
okay,
Corrections.
but they're no
So they're
longer a
not
child, then.
technically a child anymore, but they're
There you go.
serving a sentence for something that happened when they were a child. Their
Okay.
brains are still underdeveloped. That
then-
continues up until 25 for most
Gotcha.
youth.
And then, this is before imposing a sentence under this section, the court shall consider. I assume this is in addition to any aggravating factors, the nature of the crime and the like. This isn't intended to be exclusive of those. Is that right?
I will allow my colleague to answer that question.
Just briefly, and thank you for the question, Senator Castley. Again, this is a bill that contemplates additional things to consider and for a court to articulate outside of what they already could articulate. I think it is really quite similar to contemplating the sentencing guidelines, right? A court
Well,
has to.
It's a really simple question. You weren't intended to exclude the aggravating factors. You're just saying, in addition to the nature of the crime and other aggravating factors, here's some mitigating factors you have to consider, right?
In addition to everything the court may already consider, we
Okay,
are asking them to
thank you.
consider these.
Just one real quick question. So if someone's charged as an adult, a youth charged as an adult, pending pending trial, where are they incarcerated? Where are they held? In a DJS facility, or are they held in adult prison?
So that depends on what their status is. So if you have a 16 or 17-year-old who is eligible for transfer, they are held in there is a presumption that they should be held in a juvenile facility. However, 16 and 17-year-olds charged with murder are not eligible for transfer, and therefore they are held in the local detention centers. It varies from county to county how they're actually treated. I will say that some counties keep them separate, have a youthful unit where those children are offered education and kept separate from adults. In other counties, such as the one where I practice, those youth, 16 or 17-year-olds, are held with adults in the same cells as adults, without any education, without any services, without any separation from the adults. In fact, sometimes they're held in the same exact cell as somebody 2 or 3 times their age.
There's already a law on that. But,
I think there's a federal,
yeah,
you're right.
I mean, I thought we had testimony on this, like, over the last 2 years, that to put a
It's-
child in a cell with an adult, they have to be, it can be in the same they could be in the Carroll County Detention Center, but they have to be in a separate area that's sight and sound excluded from the adult. So if they're doing that, I mean, that's a clear violation of existing law.
Yes, so there's 2 federal laws that apply in this area. It's the Prison Rape Elimination Act, and hopefully I'll remember what the acronym stands for, but JJDPA, Juvenile Justice Delinquency and Prevention Act. Both of those bills are federal legislation that is meant to protect children who are in adult custody, and that's the Prison Rape Elimination Act is where we get the sight and sound language. The Juvenile Justice Delinquency and Prevention Act, which Maryland is actually technically out of compliance right now, but I believe that there's pending legislation before this committee to fix that. Both of those would require these children to be held in juvenile facilities.
Well, they're not
However,
bills, those are laws, right?
those are laws, however,
They
Maryland right
wouldn't-
now,
It's not they would require, they do require.
they do require it, however, Maryland is not currently in compliance with JJDPA. Maryland is currently out of compliance because 16 and 17-year-olds have no mechanism to be sent to a juvenile facility. And the Juvenile Justice Delinquency and Prevention Act, I know that there's a bill that was introduced by the Department of Juvenile Services, would fix that problem that we have right now, where Maryland is not in compliance with the federal law and risks losing federal funding. But to answer the earlier question, though, about the Prison Rape Elimination Act, it's the Department of Corrections is in compliance with that. It's the local jails, where it's a county-by-county policy about whether or not they're compliant with the Prison Rape Elimination Act. And some counties are fully compliant, some counties are less than compliant, and some counties have offered the opinion that it doesn't apply to them.
Okay, thank you all very much. Did we hear from Sara Cruzan? That's the video, got it. All right, well now.